I'm John Geiringer with Barack Ferrazzano Law Firm in Chicago, here at the NASDAQ Marketplace, speaking at Bank Directors Boardroom Forum on Lending. What we like to tell our clients is that banks these days need to engage in ongoing and robust dialogue with their examiners, and that occurs even before the examiner steps foot in the bank. We like to have pre-meetings with the regulators, at which the bank explains to the regulators the good, the bad, and the ugly that's occurring in the bank, so that the regulators are aware of the fact that the board is able to assess its own risk and deal with those issues promptly. First of all, during the examination process, it does make sense for the directors to send a representative to important meetings. Directors should also be aware that they should encourage management to respond in real time to any disputes with the regulators, and then follow up as necessary. So what should directors know about enforcement actions? Well, for the most part, enforcement actions at banks are corrective and not punitive in nature. Directors should be aware that the examiners view it as a roadmap to bring banks back up to health. That being said, it is incumbent upon management and the director to ensure that they get the kind of enforcement action that best suits their bank, and there's plenty of room for negotiation before an enforcement action becomes final. Once an enforcement action is placed upon a bank, directors and officers need to ensure that they have complied with every element of the enforcement action, and typically that's done through the use of checklists and tickler systems and responsibility charts. The bases for the FDIC's lawsuits against directors and officers of failed banks include negligence, simple negligence, breach of fiduciary duty, of loyalty, and of failure to supervise. The specific allegations that the FDIC is using in their lawsuits against officers and directors of failed banks include failing to comply with applicable laws and regulations, failure to comply with the bank's own policies and procedures, risky lending strategies, and failure to supervise management. At Barack Ferrazzano, we represent over 250 financial institutions from around the country. And as head of the regulatory practice area of our firm, we have negotiated over 100 enforcement actions, not to mention the board training we've done to help ensure that our directors comport with their fiduciary duties.